然后这些问题呢，就是说你们自己要事先考虑一下。
Thank you all so much for taking the time to come out today. I know this was a lot of information, so if you have questions today, we're both happy to answer them for you. If not, if you go home and the more you think about it, you realize you have more questions, our contact information is up here on this slide, and we also have business cards that we can give you. Feel free to take it, call us, email us later on if you can think of another question.
All right. 有一点像细节的问题啊 ，little bit detail question 关于这个遗嘱的验证时间，就是 okay, let me just English then talk to you. One of my colleagues said she's still alive. She won't go to the public court to validate the will.
关于这个遗嘱的验证时间呢，就是一般来说是人死了以后，这个遗嘱这个法院去验证是不是真实。但是我的同事他说呢，他现在把遗嘱做完了，他现在把这个遗嘱拿到法院去验证。So this question about a little bit detail about timing of validating the will. In the slides it mentioned when people died, the probate court will validate the will. One of my colleagues, she just completed the will. She said she wants to bring the will to the court to validate when she's still alive. Is that the timing? So can you talk a little bit more about this?
You can take your will to the probate court, but if you're still alive, the probate court does not care about that will. They only care about the will that you last did, and that is going to set up a will contestation. So it is better to not give the probate court a will unless you are worried that somebody is going to lie or fib and claim that there's another will that they falsified. But you can take your will to the probate court prior to your death. It's just not going to be effective until you die.
Makes sense. Okay. After death, basically.
After death, yes, sir.
Okay. Second question. 第二个问题啊，就是说
Let me bring you the microphone because I can't hear up there. I'm sorry.
第二个问题就是说，把资产转移到信托里面，你需要通知你的这个title company 吗？就是 the second question is when you fund the trust, right? You contribute assets to the trust. Do you need to contact your title company if the property, the assets are real estate property?
It's a great question. When you move your property from your name or your entity's name into a trust, your title insurance is no longer valid. It is void. So title insurance is what your bank requires you to get when you buy a property. And when you buy that property, that title insurance, you have two policies. One for the bank and one for you as the owner. And what that title insurance policy does, if anybody comes in and says, hey, that's my property, or hey, I have a loan against that property, the title insurance hires a lawyer, they fight the fight, and they make sure that that property is correctly just yours. And if there's any cost to it, the title insurance company writes the check. When you transfer title without the benefit of a title company, you do not have to let your title company know you have moved it, but you have now voided that title insurance policy. Technically, you don't have to let your bank know you moved it, but you are going to trigger an event of default with your bank if you do not. And your bank can then call your loan and say, you now owe 100% of the debt to me now. So when you do transfer assets into a trust, into an LLC, anything of that nature, that's where I was talking about, you have to look at the details, because there are certain people that you have to work with to make sure that that protection carries forward, to make sure that your lender is okay with it, to make sure that your title insurance company will change and amend their policy, things of that nature. Does that answer your question?
Yes.
Hold on one second.
actually have similar question on that. So I actually tried to move my property, the rental property, to the LLC, but the mortgage company said that I have to tell them to change the name and everything. And but also my title insurance said that if you move your property into the LLC, then the title insurance will not work, because then they told me that if you move the property into this LLC, but put to a revocable trust, and it will continue to work. So I just want to confirm. Yeah.
So the question was, could you move your property out of your name into an LLC or move it to a revocable trust? Her lender said, you can move it to a revocable trust, we're fine with that. But you cannot remove it to an LLC, we're not fine with that. The reason why the bank says that, it's a revocable trust, the bank still has the ability to come after you individually for liability. When you move it to the LLC, then that transfers over the liability to come after that property. And then that creates an issue for the bank. They now have to sue your LLC. Another thing that happens when you move the property out of your individual name to an LLC, if it is your primary residence, for example, your tax rate is going to go up from 4% on your real estate taxes to 6%, because you're going to pay more property taxes holding that property in an LLC or in an irrevocable trust. There are some counties that allow you to move it to a family trust and it still remain your primary, and they will keep the 4%, but you have to prove that that's done for estate planning, and you have to hope that county is flexible enough to work with you to where you can keep that lower tax rate. Why is the bank allowing for the revocable trust? Because again, the revocable trust is just really an extension of you that you haven't cut off. When you put that asset into an LLC, you've cut yourself off from it. When you put that asset into an irrevocable trust, you've cut yourself off from it. And you've changed the game, and now that changes the way the bank assesses the risk on the loan they made to you for that property. Does that make sense?
Yes. So since the title insurance will not work with the under LLC, and it will work under the trust, can you use the LLC put under the trust so that it continues have the benefit?
That actually is a good question, because you raised two questions with that one question. Number one is, when you move the asset into an LLC from your individual name, you have voided that title insurance policy. You have to get a new title insurance policy. When you own an LLC, when you own the property in an LLC, and the membership interest is in your individual name, and you transfer that membership interest to the trust, the LLC still exists. The title insurance is still good. You just have moved the ownership of that LLC from you personally to that trust. That does not void the title insurance.
So you said if I move the property to the LLC, then the trust owns the LLC, the title insurance will continue to work, right?
So long as you bought the property and got the debt in the name of the LLC, the change of the membership ownership of that LLC does not impact the title insurance.
Can you repeat that?
Sure. Let's say you buy this building, and you own this building in an LLC, and you got a title insurance policy on this property for your LLC that owns this property, and you own it personally. You're 100% owner of the LLC, okay? But you are not the owner of this property. The LLC is the owner of this property. You are the owner of the LLC. There's title insurance written for the benefit of the LLC, not for you individually. It's like having stock, right? It's like you own shares of Apple or a big company. It's just an LLC that owns this property. If you sell or transfer your interest, your shares, your stock, your membership interest is technically the right word, to a third party, like a trust, that does not void the LLC's title insurance. Now, it may trigger a default under your lender's loan documents, but in terms of the title insurance to yourself, that title insurance stays with the LLC. It does not matter who owns the LLC. The title insurance is still valid if you change the ownership of the LLC. As long as the LLC does not change the property to somebody else's hands.
I'm sorry. I think
We got the question away. So my problem is I have the property under my name,
Okay.
but I want to put it under the LLC, but they will change the title insurance. But I won't have the title insurance without buying a new one. So I put it under a trust of the LLC.
got it.
As long as your lender is okay with that, that's an indication that they are okay with the title insurance staying valid. I would have to look at what's called the title insurance policy to determine if that was an acceptable ability to move that into a revocable trust. But I believe that your bank would not allow that to happen if that title insurance did not remain valid, because again, the bank requires a lender's policy, and you have the election to get an owner's policy on your title insurance.
Yes.
Okay. So I believe if the bank is saying yes, then more likely than not, that means the lender's title policy is still valid. And if the lender's title policy is still valid, more likely than not, the owner's title policy would still be valid.
Thank you.
Yeah. That's a unique question. That's a good question.
So the question on Zoom is says, me and my wife, after retirement, we are planning on going back to China. And they believe, they trust their kid, the son, to take care of their asset in America. They wanted to give a durable power of attorney to their son. So if they do pass away in China, can he have the right to fully control their asset and do not have to go past the probate court?
The durable power of attorney will not block probate. And the durable power of attorney will work with the parents in China. The child in the United States can use that durable power of attorney. However, probate has to be opened where the assets are located. So if they pass away while they're in China and their child is here, they still have to have a will, or they still have to have some information, and a probate court would have to be open for that asset to be distributed to the child or whoever the heirs are or whoever the will says the property is going to. So the durable power of attorney fixes one problem. They go to China, they don't have to worry about being in the United States to sign anything. They don't have to worry about signing something in China, getting it notarized, having it FedExed overseas. The son can do it with the durable power of attorney. But upon their death, that doesn't take the place of probate.
这位先生，我跟你在 Zoom 上，这位先生跟你解释一下哈。这个 durable power of attorney 它并不能帮你避免这个 probate 的这个程序，它只是说你的儿子可以帮你全权处理你的资产。但是呢，就是说来避免这个程序，你唯一的方法就是遗嘱和信托。Any other question?
我问一个问题，就是你知道，是这样的，建立这个遗嘱以后，就是说这个律师事务所跟我之间是什么？之后是什么联系？比如说我建立遗嘱以后，我可能之后的几年或者几十年都不去变它，但是我这个保存的过程中，我是怎么律师事务所怎么跟我交流沟通，甚至我怎么样保存这个遗嘱，在我有突发事情发生的时候，这个遗嘱怎么样产生效果？
Okay, so his question is, let's say he set up a will with you, okay, and then 20 years pass by, nothing happened, and then 21 years, something does happen. How does he, like, how do you know when the will has, come in fact? How do you know, like, how do you connect or keep contact with them?
Good question. I do not keep contact with you. Unless we're buddies, unless you have more business for me to do, I do your will package, I give it to you, you make sure that you keep it in your important documents, and then your family, upon your death, calls me and says, bad news, your buddy, your client from 20 years ago passed away, we need to probate this will. That's when I get involved. One of the things that you have to be careful about is who you give that will to. Almost every attorney I know does not hold on to the will. The reason why is they do not want that liability to carry on for an extended period of time. Plus, law firms break up. Lawyers die. What happens when they die or they break up and that will gets lost in the shuffle? That is a liability the lawyer does not want to hold on to, which is why they do not keep that original will. That's why it goes with you, and it should stay with your important papers, and you should make sure that the right people in your life know where that important paper exists. So when something does happen to you, then they can call either that attorney or whoever you're using at that time. Now, I still want to be your friend in 21 years, and I hope I die before you do. But
那如果比如说刚才你提到就是不在，或者是这个律师事务所倒闭了，怎么样证明这个遗嘱还是有效的
？OK， 我先翻译一下他就是他的回答啊。那么就是说，律师他们是不会收着这个遗嘱的 ，OK， 他不会存档，像我们房产经纪，我们这边要存档7年，但是作为遗嘱的话，他们是不存档的。遗嘱弄完之后，他是把这个遗嘱给你们，2份原件都给你们，你们自己带回去，你给你们自己的信任的人 ，OK。那如果你以后去世的时候，你的爱的人，他们会拿着这个遗嘱，就是打电话给律师，或者是他打电话，他可以不打给这个律师，他可以打给你们自己的任何律师。这个遗嘱是具有法律性的。他说为什么律师不会存档这个遗嘱的原因，是因为第一，他说律师事务所他也可以就是分手，对不对？他 partner 他们也可以分手，律师他也会去世。那万一这个律师比你年龄还大呢？他万一他也出意外了呢？对不对？所以他们是不会存档任何遗嘱的。OK， what was the question answer? Oh, so he said, what if, for example, your law firm have break apart? Is the will still legal?
yes.
你的遗嘱他们做完以后，他们任务完成了，你要自己保存。那么怎么鉴别这真假呢？上面有签字，3方的签字都要最初的签字 original。所以说这个问题就是很好的问题，但是细节要。
之后不一定一定要找这个律师，你可以找任何一个律师，那个签字是有效的。
就是说这个遗嘱自己存，所以还要发一份在比较信任的人身上，对吧？
practice 只有一份 original。The best practice only one original signature.
Right.
You can copy give your trustee.
Right. You do not want multiple originals floating around. It's like the old American movie Highlander. There can only be one. There should only be one original.
我刚才听那个锦衣说是有2份呐。
不是，我的是这样子，我1份，我老公1份呀。对呀，因为我们2人要是不是同时去世怎么办？
对，主要是想明确一下，就很多人有个疑问，就是这个遗嘱立好以后到底放哪？就是
保险箱。
12怎么办？这个问题，可能后人都找不到。
当然，就是大家都说
哎，真实存在的，有些人就单身一个人，怎么办？
trustee 要有 copy 有附件 ，trustee 有附件。More questions. Do you want to choose some water?
No, thank you. I'm good.
Okay.
就是刚才就说到那个 medical 的那个 part 的时候，然后就是说这个就好比就拔管的这个过程哈，就是说如果假如说我现在写的是我儿子，假如说，但是也许我在他成年之前我就也许有意外，可能需要面临到这样的问题，那他做不了这个主的话怎么办？
那你爸还有老公吗？
就是说他会自动的就转到老公。
比如说2028年之前，还没成年之前。
对，你自己写好，就是你可能会写 OK， 在我孩子就是你像因为我高龄产妇，所以呢我当时我就说 OK， 我如果生孩子的时候出现了任何的 complication， 出现了任何问题，那么我要求我的老公怎么做 OK。那我就已经说好了，我老公在面临就是最大的就是电视剧里面写就是演的，你保大保小，对不对？你要怎么样保这种，我全部都 cover 住了。我就跟我老公说，你不用做任何的决定，都是我自己做决定 ，OK。 然后你这个时候你就说好，而且你可以限制时间，你可以做非常非常多的。像我有一个朋友读大学的时候，他家里是一个非常出名的企业，非常非常大上市公司。OK， 他们家对他一个最大的一点是，他们什么时候可以拿到多少的遗产，是在于他们达到了什么要求。打个比方，你如果大学毕业，你可以拿到多少钱？你如果30岁之前达到什么，你可以拿到多少钱？但是如果你吸毒，你所有的资产全部没有了；如果你凶脚，你所有的资产全部没有了。所以他们家族的孩子现在已经是第4代了，每一个人都非常非常的优秀。所以因为他们在他们的那个信托里面写了一个我当时所说的3代信托，当时就是说的这个家族。OK， 然后我的那个朋友当时读大学的时候真的非常非常努力。为什么？他说我要大学读完了，我才能拿到多少钱可以买车。
这个办法很好，我们也是。如果设立任何信托的时候呢，如果想给自己的孩子，大家多多少少有一点资产嘛，就设立到你如果大学毕业了拿多少，如果你大学没毕业能拿多少，所以每一个孩子你不用盯他们自己学习好了。
Okay, any other questions?
If I could, can you talk a little bit more about the spousal elective rights?
Yes, and I'm glad you brought that up, and I'll finish on this note. Hopefully, again, if I can help you all, please feel free to call me or Brooklyn anytime. Thank you so much for the opportunity to speak to you all today. But in South Carolina, we do not have common law marriage. I think it's also referred to as factional marriage. Is that right? No common law marriage.
Okay.
So,
one question is just in the United States have a certificate is fine, right? Not all.
no,
We have to have
it's state by state. You have to have a marriage certificate that's valid in another state when you come to South Carolina, or you're not married. If you were in California and you were qualified under common law marriage in California, moved to South Carolina, you are not legally married in South Carolina.
So what happened? Oh, really?
If you get divorced in South Carolina, you will not get alimony if you're not legally married. If you are not legally married in South Carolina, you will not get the benefit of the elective share. And that's what I believe Bruce was asking about. You cannot die and try to write your spouse out of the will. You have to leave your spouse. You have to be legally married to the spouse. 1/3 of your estate. They can elect to take 1/3 if you gave them nothing, or they can elect to just leave it alone. That's why it's called an elective share, because the surviving spouse gets to decide what they want to do. But if you're not a spouse, if you're not considered legally married, you do not have the right to that elective share in South Carolina.
But that ended with the marriage certificate issued by state of South Carolina, is that correct?
No, it doesn't have to be a state of South Carolina specific, but I know I have some clients here who've lived together for a long time, they have children, they act like they're married, they have the same checking account, they have the same last name, but the reality is they're not married. So when they break up, they don't have to go to another court I didn't mention earlier. It's called the Domestic Relation Court. That's also called as divorce court. They don't have the benefit of going to divorce court. They have to go to common pleas to separate assets. They don't have the benefit of alimony. They don't have the benefit of the elective share. They do not get the rights and privileges of the spouse. That said, there can be a certificate that's legal in one state that will carry forward. South Carolina does provide reciprocity, but it's got to be a legal marriage that is codified with a certificate that meets South Carolina guidelines, and that would be probably a case-by-case basis. But if there's no certificate at all, and it's only common law, or you think that you've been with this spouse for 10 years, but you never were married, you are not married in the state of South Carolina. That changed in 2020. It used to be different. We had common law marriage in South Carolina. The law changed, and now we do not.
We understand most first-generation immigrants, they probably married
In China.
foreign country.
In China, yes.
Yeah. Also, most younger people probably marry in different states, like state of Massachusetts or California, and then move to South Carolina. So they basically still legally married in South Carolina, correct?
So do they need necessary to get a certificate of marriage from?
I think so.
The young people who get married that you mentioned, if they got married and they went down to the courthouse and they got a marriage certificate in Massachusetts, they're fine. They don't need to do a thing. If you're coming over from China and you were married under there, it's worth asking somebody to look at your certificate to make sure you're considered legally married. More likely than not, that certificate is going to be okay. But if you came from a state where you were common law married, that is not going to work in South Carolina.
然后以前还有个人问过我，他说如果我们是在2020年之前就是已经属于事实婚姻，那2020年之后，如果我们要就是离婚，就是是不是需要经过离婚？2020年之后，不论你以前就是是不是事实婚姻 ，it doesn't matter，OK， 你还是要去拿真正的结婚证的。所以我很多客户他们就是没有真正拿结婚证的，我都会跟他们说，当我知道了这一点之后，我说还是去拿个结婚证，因为只有这样才能真正的保护，就是保护自己。
Yes, ma'am.
Okay. So if a couple, they have the property all together, when they write the will, they have to write separate. So how that will work?
That's a great question. If you're married, there's a couple different types of wills. You can do a marital will that says, hey, when I die, if I die first, everything goes to my spouse, and then the will triggers for how the spouse wants it to live. Or you can have, each of you have a will individually. You can do two wills, or you can do one will. You can do it either way. But I recommend you do two wills in that scenario. Because if you get divorced, before you either pass away, it is as if your spouse died before you in your will. And that stops you from having to go get a new will when you have a marital will. That's why I like two wills instead of one.
So in the two will, how you going to classify like where the property goes, who going to have this and that, because the property is all together?
Right, because what you do is you say, my interest in that property will go to my spouse, or my interest in that property will go to my kids, my interest in that property will go, both of you dictate. But in the event of divorce, then it would act as you passed away, and it would still be valid. If y'all were married, you would have to go and get new wills at that point.
OK， 我们已经到时间了，
分开的比较好
不好意思，因为已经到12了。
Sorry, 12 o'clock here have class, so we're already past the time. So anybody have another question? So you guys already have a business card, right? So
Yeah, call him up.
call him up.
Please. Thank you all. Thank you, Sarah.